Hello, once again, this is Brother Teacher. One of you asked me a question um, about debt collectors. I would assume that it's in relationship to a video that I did early on about never pay debt collectors again. I'm going to recap once again, just in case someone did not actually get the context of what I was saying. The first thing I want to remind you of and to even introduce to some others is this. By no means am I encouraging or advocating anyone to not pay your bills or not pay your debt. Understand this. There are provisions in our laws, in our statutes, in our regulations that protect you after a period of time. In most states, this is called a statute of limitations. And it means that certain bills or debts that you have not paid in a while, they fall off according to your state's statute of limitations. Now, you have to find out what that period of time is. For example, in some states it's 8 years, 7 years, 6 years, 5 years, or whatever. Your state has already in the books. But when you have a bill to pay your bills on time. If you are one of those individuals, one of those unfortunate people that may have been, let's say, incarcerated, and you come back out and there was something that you had that was still owed, and the time that you have been gone away, if you will, or locked up, that bill is still there to haunt you, and you have passed the statute of limitations. A lot of times people don't know that there is a statute of limitations, but I'm letting you know now that most states, if not all, do have this provision. You don't have to pay that bill, notwithstanding, and I've said this before, child support and college loans or loan debt is not applicable in this particular case or instance. You cannot basically charge this off. So you do have to pay that. Now, as far as debts like hospital bills, utility bills, phone bills, car notes that are delinquent over a period of time, and I'm talking about a period of time, not meaning months, but years that have passed by, there is a remedy. Now, understand this. Most major corporations, and they would be foolish if they didn't, but most major corporations have insurance. Most of them are protected. And what I mean by that is this. Once you become delinquent in a payment, after a certain period of time, sometimes it's 180 days, sometimes it's longer, and you haven't paid on a bill or paid a bill, they write it off to get it off of their books. And it goes into sort of a suspended file, so to speak. And you no longer owe that debt. They've been reimbursed by their insurance company or some other aspect of the law covers that debt. So understand this. Very rarely do they just strictly take a loss. That's not the way it's done in business. Now, listen. If you, after you pass the statute of limitations for the debt that you owe, if you by any chance pay anything on that suspended debt, you owe it again. It starts all over again. So basically what you're saying is that I do owe the debt just by virtue of your act of paying something towards it again. Now, if that doesn't happen and you're past the statute of limitations, understand this. There are collection agencies whose sole purpose outside of the institution that you owed, they will buy your debt from your original creditor. Now, understand what I just said is debt. It is not something that you owe the original creditor anymore as long as you're past that period of time where they've already suspended it. But they're not going to call you, the original creditor that is, they're not going to call you and say, Mr. Johnson, you don't owe us anymore. They're not going to do that at all. It is your responsibility to do your due diligence and stay on top of your legal issues, your lawful issues even. So, if you're past the statute of limitations, and this credit collection company, which is a private collection company, and there are many of them, hundreds and hundreds and hundreds of them. So, you're going to get a ABC collection company or under some other crazy title. They're going to send you a letter after they bought your debt for pennies on the dollar. They're going to send you a letter and they're going to try to recover the full amount that you last owed your creditor, even though you don't owe them anymore. But you don't know that, and they want to make you believe that they are actually representing that company. But one thing that they won't tell you is that they have no contract. So if you challenge this, if you ask them to send you, if they send you something, for example, by virtue of mail, you say, send me a copy of the contract. They'll never do it. But they will continue to harass you. They will continue to threaten you. They'll threaten you with taking you to court and so on and so forth. They are not able to do that. Please believe this. They are not able to do that. If they are if they are a collection agency that's part of the company that you owe the debt to or the creditor, and your debt hasn't been filed away, you have to pay them, or you could possibly go to court. I'm talking about independent credit collections agencies that are outside of the agency that you originally owed the debt to. Those are the only ones I'm talking about. Understand that. These guys are criminals. They would threaten you. They would send you what appears to be legal documentation in the mail. They can't call you after 8 o'clock at night, and they can't call you before 8 o'clock in the morning. Understand that. That's two things that you have on your side, according to the Fair Debt Collections Act. Okay, now, getting back to this. My subscriber and or viewer of this one particular video, I would assume again, he asked me the question, what if you are called to court? Understand this. The only way that you can be called to court, first of all, is not by the credit collection company that's outside of your original debtor or creditor. Understand that. If they send you anything that looks like a court paper, it's probably not real. It's probably not legitimate. But that is actually stooping a little low, because most of them won't do that, because they usually can threaten people and coerce people into sending them some form of payment. But if you are called to court, chances are it is still the same company that is your original creditor, and that your debt has not been wiped clean from your slate. And you should go to court. But if you've been making payments, this is just a side note, if you've been making payments towards your creditor, towards whatever your bill is, in most instances, they can't sue you as long as you're making a goodwill effort to make payments, even though you cannot afford to pay the amount that they're asking. So understand this also. If you're called to court, let's say you have a date to go to court in a month or in 2 or 3 weeks, draft up a letter. Send that letter to them. But before you send the letter to them, make sure that you have it notarized. Make sure that you let them know what your standing is. My name is so and so, and I understand that I owe you a debt. I owe you X amount of dollars, or what have you, whatever the case is. That is if you're not your case, but if you still owe the debt to these people and it hasn't been suspended again. So you write them a letter or type them a letter, and you say, this is how much I'm able to pay you monthly. I'll pay you on this same date every month until my debt has been satisfied. You write them this letter and you tell them how much you can actually afford, and you go and buy your money order for that same amount and you mail it to them. They can't refuse it. And you do this before you go to court. Don't wait till it's court time. It's too late. Okay? You send this money order to them and send it to them. If they try to send it back with a letter saying that they refuse it, you have evidence right there that proves that you tried to make a good faith payment to these people and they refuse the payment. Sometimes the judge will throw it out of court because you made an effort to pay and they didn't accept the payment, no matter how much it was. I've seen this work before. I have schooled people on doing this before. I'm not saying that it's going to happen 100% of the time, because I don't know everybody's case. I don't know everybody's situation or circumstance 100%, because when you're talking on the internet with someone and they give you a generality of what's going on with them, that's all you have to go by. Unless they're sitting in the room with you having a conversation and telling you everything from the beginning to the end, you have no other way of knowing exactly what their circumstance or situation is. So please understand that. Now, with that said, pay your debt when you owe someone. If you can't pay your debt, you send your creditor a letter and let them know how much you can pay. Send them a money order, cashier's check or what have you, with the amount that you can pay. This doesn't work with everything, understand this, but make sure that you have it notarized at a bank or a public notary somewhere. Make sure you have it notarized. Make sure that you have 2 or 3 extra copies of your own, and you send it to them. You can send it to them certified mail as well. That way you know that they received it. Understand this. This is Brother Teacher. If you have any further questions concerning this subject or any other, please let me know in the comment section below. So long, and I'll see you.